Chapter 4, we deal with intellectual property. So intellectual property is basically any property that is a product of someone's mind. So an author, you write a book, or a IT guru and you make a software program or an app. Producers who make movies, musical artists who make and record music, all are, artists who do paintings and sculptures and things like that. All of that is intellectual property. So we have laws that protect and reward that type of creativity. So these laws are designed to protect the intellectual property so that only that person can prosper or make money off of it for a specified period of time. So we'll talk about patents and copyrights and trademarks and trade secrets. All of those, kind of can come into play with business. So a trademark is a distinctive mark or emblem that represents that product. So think about the golden arches. We all know that is McDonald's. The little swoosh for Nike. There's so many trademarks. Really, if you just look around anywhere, you're going to see a trademark that relates to that product and identifies that product in the market. So those are going to be protected. As soon as someone files for that trademark, that owner is going to have exclusive use to that trademark, and nobody else can use it, even for other goods. So even, with the golden arches, all of a sudden we couldn't put those on shirts without people thinking, was McDonald's making shirts? Because you would think that if you saw those exact same golden arches. So how it can be infringed is when there's some sort of confusion. So like what I just said, if all of a sudden a shirt maker decided to put the exact same golden arches on a shirt, if we were just a little bit confused to think, was McDonald's making those, that would be enough to cause trademark infringement. It can even just be substantial copying of it, so it's not 100% or it's not exactly, but it's enough, again, that a reasonable user or a reasonable consumer could be confused. Counterfeit goods are ones that, that people try to pass off, like a Gucci handbag, those kind of things. If you go to New York City and you go down Canal Street and some of those little sidewalk markets, a lot of times those people sell purses and watches and things like that could come across with that Gucci label, but they're not. So they're going to be a fraction of the cost, but it looks like the real thing, and you're going to pay them cash and you buy it. Those are trademark infringements. I mean, those people could be sued and could have legal charges pressed against them. There's other different marks that can go along. So a service mark is similar to a trademark, but it's not for a product. It's for a service. So like UPS or Delta Airlines, they have their distinguishing marks, but they're not necessarily a product as much as they're a service. So when we see that big brown truck with the UPS and the little shield, we know, hey, it's a UPS man. Where, again, if somebody else came in that truck and copied it, that would be an infringement on that service mark. Certification mark is things like a good housekeeping seal of approval or recommended by the American Dental Association. You see some of those marks on different products that you purchase. A collective mark is when a union is responsible for producing that product. Trade dress, it happens all the time, I feel like, especially in restaurants, but even retail. There's a distinctive decor of, say, like a TGI Fridays. So it's got the red stripes, the servers dress in a certain way, the outside of the restaurant looks a certain way, or the Cheesecake Factory. And again, a very distinctive decor. It doesn't matter where you go. They all kind of have that, that big pillar look inside. So those are examples of trade dress. And again, other companies can't copy those, even copy them substantially, or they could be charged with infringement. Okay, patents. So patents are filed with the U.S. government to protect the right to make and use a design of a product, the process used to make that product, if it's a brand new invention, something that's never been sold before. And so they've got the right to profit from that for 20 years. Then after that, it's public domain, so anybody can make it, but at least it rewards that person who's designed it and researched and developed it. So a lot of times, like, think of pharmaceutical drugs. After those 20 years, they'll go into generic, and then you can get them for cheaper. But during the first 20 years, they're going to be a higher priced because they're trying to pay the companies that have spent millions of dollars of research and design for that particular pharmaceutical drug. So obviously patents can be infringed, so somebody else copying that process, that pharmaceutical drug, copying the model of a car. So it doesn't even have to be entirety, and it doesn't have to be for the same purpose, but if it's copied substantially, it's an infringement case. And what they could sue for is an injunction to say, okay, you can no longer sell this product or use this patent, maybe ask for damages for lost revenues, and then reimbursement for any legal fees, because a lot of times that can be extensive, especially to a small business person or an individual who owns those patents. Copyrights are probably the ones that are the most often infringed upon, and they are infringed upon by just general people. You and I can be guilty of copyright infringement. So a copyright, it protects the art or the written work for the life of the author and artist plus 70 years. So for their lifetime and really their kids' lifetime. So it's got to be a work of art, any type of literature or written document, music and films, and then architectural work. The only exception we have is we can use it for education purposes as long as it's not something that we should be purchasing. So like I couldn't copy a whole chapter of a textbook and give it to you because I could probably ask you to buy that even if it's just one chapter. Most publishers will sell you that. So that would be copyright infringement if I did it. Now if I wanted to play you a video on business law that I find out on the internet, I could do that and use the fair use exception, because, and not pay royalties and not charge you to see it, because I am using it for educational purposes. You just have to be careful when it's like textbook chapters, because those you can purchase. Now, so where most people come into play with this copyright infringement is with these file sharing downloads. So if you can go online to various sites and download, top music or the new release of a movie and not pay for it, that's copyright infringement. So even if they're just calling it file sharing, it's still a way for people to get those types of products that you should pay for and get them for free. And it can be punishable by damages, fines, even imprisonment, depending on the level at which you're guilty. And you could also be guilty of copyright infringement like in a paper. If you go out and you Google search and you copy someone's whole paragraph that they wrote and you put it into your paper without referencing them as a source or using them too much in your paper, that's copyright infringement. Trade secrets are things that businesses have that kind of make them special and give them an edge over the competition. So maybe it's customer lists, maybe it's specific computer programming, there's secret recipes or formulas that they use in their meals that they serve. Maybe it's a specific way that they price their product, but things that they would not necessarily want their competitors to have access to. So the thing about that is normally who's guilty of theft of trade secrets is employees. Because in today's world, you can download those files, put them on a little zip drive, put them in your pocket, and out you go. 20 years ago, you'd have to take the file cabinet with you, which would be far more obvious if you're stealing trade secrets. Now everything is so digital, it happens far more frequently. Or again, a disgruntled employee even could just do it just to be mean. So here's an example of, this person develops this espresso machine called the Express Lane. They give it the EL logo on the cover of the espresso machine, and they package it up with an instruction manual and sell it to consumers. So they could have all of these different intellectual properties. They could have a trademark protection for the EL logo as well as the name Express Lane. They could have a patent of the design of the espresso machine if it's somehow different. They could get copyright protection on their instruction manual, and then they could even have a service mark or trade secrets. But I feel like the trademark, the patent, and the copyright are the kind of guaranteed ones that they will definitely have.